Okay, so it's 9:01 on Thursday, October 10th, 2024. This is a regularly scheduled session of the Baltimore County Board of Appeals. We're here for a public deliberation in the case of AL Glenview LLC, legal owner, and Tikva LLC, the lessee, having to do with a petition for special hearing and special exception at 800 Goucher Boulevard in Towson. And this is a request for a special exception to permit what's called a rollover car wash at a gas station convenience store, and also for a petition for a special hearing to amend the site plan that was originally filed in 1989 when I guess the gas station was developed. So I'm Joseph Evans. Here today is William Paulshock and Brian Pennington. The hearing was held, when was the hearing held? It was held about 6 weeks. It was held on August 15th. There was, once again, I have to sign out.
We can hear you on air, Joe.
Yeah. And once again, all right, I have to sign out. Okay, I'm back, right?
Correct.
I'm sorry, I keep trying to clear my screen and I keep pressing the wrong button. Anyway, so the question is whether the petitioner has satisfied the test for a special exception, as in Schultz v. Pritz, and whether the actually, I guess the legal issue, another legal issue is whether or not the entire project is barred by collateral estoppel because it was the subject of two prior cases, one in 1989 and one in, when was it, 1996, was it? Does anyone have any thoughts? I guess I could start if you want. I guess I would note for the record that there was no opposition to this. It was I mean, this is a de novo hearing, though I do think it's fair to note that the orientation of the car wash was altered following the hearing in front of the administrative law judge, so as to make sure that the vehicles exiting the car wash would not be oriented towards the residences, the apartments. I don't know if any of you are familiar with this area. It's, you know, the apartments mostly at issue are high above the subject property. There's already a lot of tree barrier there. And I credit the testimony of the traffic engineer who said that he didn't think there would be any particular increase in the amount of traffic, that mostly these would be people who were going there anyway. Yeah, it's a little hard to know for sure, but again, you know, there was no one to contradict that. And he does have some expertise in this stuff. So this is also we didn't hear any testimony, if I recall correctly. Maybe you can refresh me on this. We didn't hear any testimony about significant changes in that intersection in the past 35 years, going back to 1989, and then the hearing that was in the 96. 96, yeah. I know, and again, I don't want to dwell on the administrative law judge's opinion. There was because this is de novo, there was there was some evidence in that the intersection hadn't appreciably changed in 35 years. I find that hard to, and that came from the petitioner's witness. I find that hard to believe, actually. I mean, I've been in this area 35 years. That intersection has really become far more commercialized in my recollection since 1989. I mean, my Lord, I mean, to say that there's a couple of new restaurants is to overlook the redevelopment of that whole shopping area. It used to be what was it used to be? I forget the name of what it used to be, but now, you know, it's a huge mall, and there's, you know, restaurants in the parking lot, and there's traffic all over the place. So I don't say that there's more traffic because I'm suggesting that there's too much traffic for a rollover car wash. I'm just suggesting that circumstances are different today than they were 35 years ago there. And I think that, personally think that it can tolerate a slightly more commercialized gas station than before. That's sort of my view. Again, there's no opposition here. With regard to the collateral estoppel question, I'm answering it by saying that the circumstances are different. I'm not sure that I buy the petitioner's legal argument that the 1989 hearing doesn't count because no appeal was taken on the question of the rollover. I don't think that actually follows. I mean, if you have a hearing in front of an administrative law judge and lose an issue and don't appeal it, that counts. That's not, you know, if you appeal something else, what you didn't appeal is final and it counts. And so I don't think that's a way of getting around collateral estoppel. I think that's just a different way of establishing collateral estoppel. Personally, that's my view on that legal principle. But I do think the circumstances are different there at that intersection than they were 35 years ago and then 25 years ago. I mean, it just seems like to me, so I would be in favor of granting the petition, but I could be persuaded otherwise if either of you think so.
I agree with you, Mr. Evans. I mean, maybe a little different on the collateral estoppel, but there was no opposition. We had expert testimony that went through all the factors in
Schultz
502.7. The statute, 502.1, I'm sorry. They went through all the factors in 502.1, and also I do believe this, the extra factors in the community plan for Towson, I do believe they apply in this case. And they satisfied. I mean, the expert testified as to the required factors in that, and I agree. So that I think they satisfied they checked all the boxes on that side. Mm-hmm. So I agree that the special exception they qualify for that. Mm-hmm. As far as the collateral estoppel, I agree with you as well. I do agree with you that I guess the circumstances have changed based on what you were just talking about, the intersection, how it became more commercialized, and it's way different than it was in 1989. But I think I agree with the petitioner's legal argument too. As far as I kind of relate this to like a district court civil case. So if you file a civil case in district court, one that gets a de novo appeal, so I guess a small claim, and you file a claim, you file a case, and you have 3 different counts in your case: count 1, count 2, count 3, whatever they may be. And let's say you lose and you appeal that case, it's a whole new hearing. That district court case never ever happened. Mm-hmm. So you can proceed in circuit court on. I mean, you can change the counts. You can amend whatever you want to do. Sure. The whole case starts over in circuit court. So whatever happened in district court never ever happened, and I kind of relate that to this case. So whatever happened in the hearing in '89, they appealed it, and then in the appeal, it was a whole new case. That whole case started over, and they didn't even argue the car wash. It was just for that convenience store. Right. Right. So I kind of agree with Mr. LaFiandra's argument that it was a de novo hearing, and that issue was never brought up. And I don't think that it should have been relied on in subsequent cases, because it was an issue that was appealed de novo. So, but I agree. I mean, I get it's a very interesting legal issue, I think.
Right. I understand your point, and your point and Mr. LaFiandra's point. I would think are well taken. I'm not, I mean, you're right. It's a sort of a thorny legal question. It hasn't been briefed by an opponent, by an adversary. It would be useful right. if we were to, it would be useful to have someone who viewed it differently to weigh in on that, but that hasn't happened. And so here we are. But I get what you're saying, and it has some appeal. It really does have some appeal. I get that.
And I can see it both ways, but
yeah, right, exactly. Right.
But I agree with you. Just for the record, I do agree with you with the change of circumstances.
Yeah.
So I mean, we're on the same. We got to the same result.
Yeah. Yeah.
I agree with both of you. All the facts are pretty clear, and with the El Sapo case, I agree with both parts of that. This is different. And, you know, it's, the public did not comment on this. No one was there. It is a need for the community. And, you know, it's good when good things happen, when you have a building that was established in 1989. It's good to have positive investment in commercial
Yeah.
for the community. And you know, there is a need for this for the community. It's a positive thing. It's not necessarily, as discussed, going to increase traffic. And we all wonder what happened down there and why hasn't this changed in 35 years? Technology has changed, light skews got better.
Right.
More
Right.
coordination across the corridor on
Right.
the corridor
Right.
itself. That all helps, but there is plenty room right turn out. But I
Yeah.
do have a couple conditions I think
Yes.
would be
Yeah.
important to the community.
Mhm.
And I do believe it should be limited in hours,
Yes.
you know, 7 to 9, 7 to 10,
Mhm.
kind of a standard thing in communities.
Right.
I
Right.
think that's very important. But I think there's, look, investment of business, and I think the owner is a very wants to improve his business. Okay,
Mhm.
that's why he's building this. He's going to fix it up. He's going to clean it. It does have a retaining wall already,
Right.
6-8 feet high, and it's concrete retaining wall. Very good sound barrier. The access of the front of this is facing a wooded area, and on both entities of it, not a resident entity of the apartments or condos. My concern is if they would extend another 6 or 8 foot wooden wall.
I'm
on
sorry,
top,
say that again, Bill.
they wanted to extend another sound barrier on top of the concrete wall.
Mhm.
It's underground facing the apartments. If you put that up, the problem is, and it's not the community itself, it is the nature of what happens when you extend another wooden wall to the backside where it's not too visible other than the residents. A lot of graffiti tagging does happen. Happens in every community. But when it's on the backside but facing the community, that can be a little disturbing. Right now they have a metal fence up there. They're already 8 to 10 feet below, and they already have a sound barrier. I would suggest and recommend that another 8 foot wooden wall on top of that could cause some not good stuff with the community, and
I think that's well
dismiss
taken.
that if possible.
Yeah.
So that's your, you know, I think maybe talk about.
No, I agree with that, absolutely. So there has to be some additional sound abatement. And also, I guess, in making sure that the aesthetics are handled properly so that it's not, so that it blends in with the
Would that
tree barrier as it is, yeah.
correct? Would that 8 or 10 foot barrier that's already in play be enough sound barrier? Because if it was on level ground, they would put a 6 to 8 foot barrier up, but there's already one in play. I
But
mean,
are you saying you don't think it needs to be higher?
I do not. I do not. I think if it was on flat ground, we would be talking about putting a 6 or 8 foot barrier up.
Mhm.
It's already in play on that side to protect, and not because they did it on purpose. It's the way
Yeah, it's the way it is, right?
the way it is, you know. So, but that's, you know, we can talk about that if you want. But I think the sound barrier is already in play.
I agree.
You think it's already,
I think yeah, it's already, I mean,
Yep.
it's a,
Okay.
it's a
Now, I'm sure when he comes in, he will probably power wash that wall that's been there since 1989.
Mhm.
That's a business aspect look of it, but
Yeah, those aren't cheap. Those walls like that, those retaining walls, it's a big deal. Okay, well, I guess we can fashion whatever conditions, ultimate conditions are appropriate, but I mean, I do think that, you know, the time limitation is appropriate. I think I would probably say 7 to 9, but 7 to 10 is okay too, I suppose. What's your view, Brian?
I'm fine with either. Whatever the normal business hours in that area, I mean, probably 7 to 9, I would say.
I would think 7 to 9 for a car wash, yeah.
Mhm.
I like that.
Yeah. Okay. All right, so I guess we have a unanimous agreement here to grant the special exception and to permit the modification of the site plan from 1989 to conform with the modifications that are being proposed here. And I guess that's it, huh?
I agree.
Anything else for us to discuss?
I don't think so.
It's going to be a beautiful day out there again today.
Yeah, Brian, and Bill, that legal issue is quite thorny. And I'm actually glad we don't have to really
Right.
grapple with it, because I think it's beyond my, you know, at this stage, my intellect to deal with something as nuanced as that. So anyway, so okay, well, we will write an opinion that will be issued probably within the next 30 days, and I guess that's that. So again, I apologize for my clumsiness in terms of the logistics here, but we're done. Not even 9:30,
Right.
and so life can continue with this nice weather. All right. Okay, so we will
All right,
adjourn.
gentlemen.
Thank you.
Enjoy your day.
Enjoy.
Bye-bye.